Bonnie Yates is here,
Good
and
morning.
she's looking all lovely,
Thank
and
you.
I'm loving that blue on you.
Thank you.
And it's like an indigo. Wonderful. So Bonnie, how are you? Let's
I'm
start there.
good. Good, good. Preparing for
And
another warm day.
yes, and can you tell us a little bit about Tollner Law Offices and then give us your disclaimer?
Good morning, everybody. Toner Law Offices is the Toner Law Offices is an 8-attorney law firm based in San Jose, Los Angeles, and Irvine. We can be looked at on the web if you Google us, TOLLNER Law Offices. If you're in California and you want a complimentary initial consultation, you can get a hold of the intake form on the website, fill it out, send it back to the office, and they'll schedule something with me. On this show, one of the overriding objectives that Shannon and I have is making sure that you have as much access to information about your legal rights as possible. So we're putting forward questions of general public interest that we think will allow you to better understand how the IDA and related statutes work. As you know, if you have a specific problem, it's best to consult with an attorney in your state. If you're not in California, I can recommend you to the copaa.net website, which will put you in touch with attorneys in the 50 states. If you are in Arizona, I just learned that Amanda O'Neill, a wonderful young attorney with our firm, very, very capable, sharp attorney, is also barred in Arizona, which I didn't know. And she also does conservatorships, which I didn't know. If you're in New York, I've been referring people to Barbara Ebenstein. She's a lovely, extremely seasoned lawyer who also functions as a hearing officer in some counties in New York. So with that, we've got some questions today, right?
I just want to pause for just a second and say, when you say barred in Arizona, that's lawyer speak for she's passed the bar and she's
She's
but for the rest of it, when you say you're barred from it, it means you can't go. She can practice law there.
Thank you. She has the license to practice law in the state of Arizona. Over the weekend, I did some looking for us all at what came out of the federal process about how IDEA was going to be dealt with during school closure that was being nervously awaited from Betsy DeVos. We're going to answer some questions first and then go into that as we have time. But the really good news is I think lawyers on my side of the aisle were really braced for anything. You know, like none of the IDEA procedures apply for a year, or we're getting rid of this or that. What she came back and did, she made 2 material changes. One don't concern us, doesn't concern us, but the other one does concern us. She said that any toddler who's eligible under Part C of the IDEA who has early start services, if they can't be assessed in time to determine if they qualify for Part B services at age 3, would be allowed to continue receiving their early start services until such time as they can be assessed. That's really interesting because there's no stay put normally on those services. So that was a win, not a lose. I also sent you a little template that is put out by LRP. LRP is an excellent special education database used heavily by school districts and sold heavily to school districts. And it's very comprehensive. So I forwarded to you their template on documenting modifications to IEP services. They're also putting out tons of stuff for educators now about how to handle different issues that come up. So we're going to rip some of those off and talk about them so we can see how the other side is thinking about the problems that we all confront.
Fabulous.
So with that,
I also want to let everybody know that I'm starting a Pinterest board that's just for the goodies that Bonnie gives us, because we've been putting them in the Facebook, and then people are saying that they're having a hard time finding them later on. So I'm starting a board on Pinterest under the Autism Live big board There will be a board that's just for goodies from Bonnie Yates.
And that's going to include all the things that we cook in my household, because all we do is cook all the time now.
Well, you have a recipe for some sort of Christmas crack that's like crazy. I remember people went crazy for a couple of years ago. You made
Christmas
something.
crack, peanut butter fudge, Toll House cookies with peanut butter and chocolate chips.
Well, clearly we need a whole
cake,
cooking segment here, Bonnie.
coconut oil brownies.
Ooh,
Yeah,
okay.
it's not a problem, guys.
Well, but it's a problem that most of the world has right now because people are either buying it or making it. So there we go.
And I don't want to trivialize people who don't have enough food to eat. So
No,
I'm very
let's not do
concerned
that.
about students all over the world that don't have enough to eat. Anyway, I better stop talking so you can start talking.
But since you said that, Bonnie, I just want to make clear that most school districts right now are taking their extra food and they're serving families and anybody who needs to be fed. I know here in Los Angeles that they are serving breakfast and lunch every day at like 6 different schools. If you need food, get yourself to, look it up online and find, because I hate to think of somebody going out without food. Okay, and thank you for bringing that up. Okay, so first question, you ready? Before school ended, we had an incident where my child was being bullied. My child has an ASD diagnosis. The child who was bullying does not, but his family is very influential. I asked for a meeting with the principal and was told that they were dealing with issues related to the bullying and that they would get back to me. Then school closed. I have repeatedly asked for a meeting and have been told that due to the situation, I guess the school being closed, the bullying has stopped. So it is not the first priority. But my child will have to come back to the same school in the fall with a kid who basically got away with bullying him. What are my rights as a parent regarding this?
Well, it's an interesting problem. I guess the analogy would be if you'd raise it during the summer, they would say it's not happening now. I think based on past history, you have a reasonable factual basis for explaining to them why this is going to reoccur in the fall because nothing has changed. I don't know if the students are in the same class or not. Did the listener say or no?
No, not at all.
So whatever your facts are that reasonably suggest to you that this is going to recur, you can put that into a letter, tell them you were pretty disappointed when they refused to take this seriously and they said that other things were more important, and then give them prior written notice and ask them to tell you why they don't feel that they need to do anything about this. We've provided a template for people for prior written notice, but I did another one for an advocate last week. I'm going to send it to Shannon after the show. She can send it to you. Prior written notice basically is available to you as a remedy to get information anytime the district proposes or refuses to do something that relates to the student's eligibility, identification, services, goals, placement. So I would say that the issue with bullying is that it can interfere with the provision of FAPE because it has an educational impact and the student is not available for learning to the same degree. And I would also say that potentially it interferes in the placement if people are doing things like putting your child in the learning center or something, or in the front office. A lot of the time what happens at school is that school districts are also concerned about these kids. And sometimes these kids, through no fault of their own, they're young, they're obviously showing they have problems, can be destroying school property, can be interfering in class. So the focus shifts, and rather than directing resources toward the child that's receiving the bullying, the focus moves more toward, are we going to try to get this parent to agree that we're going to put the bully in a non-public school or get him out of here before he hurts a teacher? So we have to bring the focus back to you and your child and why this is interfering with his IEP. And I would say that in discussing these issues, it's always important to try to talk about the other child in sympathetic terms, but just saying we've got a practical problem here. It's not that anybody's bad, but this person's behavior is disruptive, probably for other children as well. So try the prior written notice. If that doesn't work, get back to me, but I think that it should.
Okay. My mainstreamed ASD child is in junior high. All of my friends are telling me that their kids' schools have frozen their grades. So if they had a B in a subject before the shutdown, they can't get less than a B for the semester. Some of my son's teachers are doing this, but his math teacher is not. He had a B, now he has a C. Is the freeze thing a rule or a suggestion?
My understanding was it was a rule, but I could be wrong about that. But I would write the district and ask if they have a policy as regards this. You can also look in their board policies, but they might not be updated. And then I think you have a basis for writing the school and saying, in the interest of, consistency and what other children are getting, it's not fair that your child with a disability, and I would underline that, be penalized for his inability to attend school during school closure, which is essentially what's going on. Ask them to discuss it with you, and if they won't, give them prior written notice.
Yeah. Okay, great. And then our last question, who will be making the decisions about restitution of services our kids missed because of COVID? Is it the principal, the superintendent, the courts? Who's going to decide?
Well, it's an interesting question. You're actually talking about compensatory education because what they're getting during school closure is not what they would have gotten during regular school year. So when you ask that question, my answer is it depends upon the level at which you're interacting with the system. If you're going to have an IEP meeting to ask for compensatory education, which is what you might very well want to be doing, here's what really is going to happen. If they know that that's what you want to talk about, they're all going to get together before they meet with you, and they're going to come up with their position. So it's unclear. It's hard for you to know at what level the process is being decided, right? But typically we do find that IEP teams make these decisions at a lower level, and then if you file for due process and you have a settlement conference, you're dealing with a whole new different group of people. I would say if it's 4 hours of speech therapy, that's one thing, but if you put your child in a private and you want comp ed, you want reimbursement, and don't forget to give your 10 business days notice or you won't be entitled to reimbursement. If you want that and it's a substantial uh, amount of money, sorry, this person's got a,
It
sorry,
happens. That's what being live is
uh,
all about.
just one sec.
Yep.
Uh, sorry.
No, it's okay.
She's got a resolution session.
Ah,
That's easy. Anyway, so I would say that you may not know that, but I would just say make your best case for why the comp ed is necessary and indicated. And we are going to see a ton of comp ed cases next year because theoretically every single child with an IEP is entitled to compensatory education for this time. You'll recall that a few weeks ago, I shared something, we can share it again. It was a paper from the Alliance for Children's Rights, and they were proposing that the federal government adopt a rule across the board, which I don't think is ever going to happen, where for every hour you miss, you get 2 hours. Now, that's probably an ask intended to be bargained down from. But
yeah.
if you think about it, and you're doing a good job of tracking your IEP services daily and weekly, you would have a basis, obviously, for trying to secure comp ed once school reopens. Now, am I so old that I don't even remember telling you this at the beginning of the program? I sent you the LRP little form, which is their idea about how you document modifications to IEP services. So that's just a suggested form. You could have more boxes and additional information, but it's
Tell me what the LRP is.
it's called, I sent it to you yesterday, it's called Template, Documenting Modifications to IEP Services.
But I mean, what does LRP stand for?
Oh, LRP, I'm sorry, that's Special Ed Connection. That's the law, the Special Ed Attorney Clearinghouse of Information we were talking about earlier in the program. I apologize. But anyway, they're sort of telling you that people should be paying attention to these things because later, I believe this is a form for educators because it says things like, Modification applied, provided the services virtually through the use of video conferencing with the student's regular service provider. That was a speech and language person. So they're going to be creating some documentation to show what they did. So you know what that means.
Yeah.
You got to have your own, right?
Yeah, absolutely. Absolutely. The part we all love. All right. Well, those are the answers to our questions. And I know you wanted to take a couple of minutes to talk about what this decision was from Betsy DeVos. I also want people to know that next week you won't be with us live on the show, but you've agreed to come and do a town hall. I started the show by talking about the PTA that we have at CARD. And we've been doing webinars, and enough people have said, hey, I feel left out, that we're going to do a couple of town halls. So it's the kind of thing that we've been doing on the PTA webinar, but we're going to make it open to everybody. So Bonnie has agreed to a date. We'll disclose that a little bit later on, but she's going to give us a town hall about the state of special education. So, but we're going to just
of the Fed.
there we go. But we're gonna give you just a boosh-moose of that right now. Because we've got about 5 minutes, Bonnie,
right.
where you can talk about Betsy. You go for it.
I'm actually going to talk about some things that the school districts are talking about as sort of a little teaser, and then we're going to have that larger discussion in a few days. And I may drop out just a minute early because I want to get back to this other attorney who's got a time-sensitive question about a meeting. So here's the stuff they're putting up that's very interesting. You guys can tell me what you want to hear about. How to protect against retaliation claims during distance learning. What does advocacy look like during an extended school closure? What does an adverse action look like during an extended school closure? How to continue MTSS during the pandemic, which is basically just modifications, accommodations, and so on. Here's one you guys will like. Districts must consider comp ed for students excluded due to COVID-19. Okay, that might be a fun one to do.
Yeah.
Coaching tips for families of children with ASD during a pandemic. So they're putting up a lot of stuff telling the district how to respond to this extraordinary situation. And I think we should be monitoring these things. So just an example, the question, districts must consider comp ed for students excluded due to COVID-19. I'm just going to read you 3 paragraphs, and then if you guys want to talk about this more, you can send in some questions. Following any school closure or the exclusion of a student with a disability as a result of COVID-19, each student's IEP and as appropriate 504 team should decide whether the student needs compensatory education. We explained that the IDEA Section 504 and Title II of the ADA do not specifically address a situation in which school is closed for an extended period of time because of a disease outbreak. Parenthetical insertion from me. Therefore, you have a bunch of issues that have yet to be litigated that are going to be litigated for the first time. However, in general, if a school closes its doors to stop COVID-19 from spreading, we observed, and the district isn't providing educational services to the student population in general, then the local educational agency would not be required to provide students services to students with disabilities during the same period of time. Well, we know that's already kind of become out of date because they have decided to provide the services. Once school resumes, the district would be obligated to make every effort to fully implement a student's IEP or 504 plan. In addition, the IEP or 504 team, as appropriate to the specific student, would be required to decide on an individualized basis whether the student needs compensatory services due to the impact of the closure. So you heard that individualized, okay? ED, that's what is it, like educational directory or whatever educational advisor for this publication, also warned districts against providing educational opportunities to the general student population during school closures that it doesn't make available to students with disabilities. To avoid discrimination, such opportunities, including the provision of FAPE, must be equally available to students with disabilities. We also stress that IEP teams should consider as appropriate whether a child excluded as a result of COVID-19 while the school district remains open could benefit from homebound services such as online instruction or instructional telephone calls. We added that while IEP teams are not required to include distance learning plans in a child's IEP, doing so might be a prudent step in view of the potential for future school closures. Creating a contingency plan before a COVID-19 outbreak occurs gives the child service providers and the child's parents an opportunity to reach agreement as to what services would trigger the use of a child's distance learning plan and the services that would be provided during the dismissal. So if we're going to see a second wave of outbreaks in the state that you're in, then this is something that the school district is telling their people it would be prudent to do. They may never get to it because they've got a huge backlog of work now. But I think it's important. We have this resource, and it just occurred to me when I was looking at this stuff over the weekend. Rather than telling you my opinion all the time, let's hear about the people that are making the decisions and what they're thinking. So with that,
we've had 2 questions that have come in, Bonnie. Do you want to hear them really quickly, or do you need to go?
I can do them if you don't need me to do the disclaimer at the end. If you can do the disclaimer after I get up there.
Okay, I will. So my son is doing an independent studies program. My district does not have a modified Edgenuity online program. Do I have the right to ask for less work? It's a lot of work and he gets overwhelmed.
Yeah, you just go back to the accommodations in his IEP and you tell them that the direction and guidance from the federal government is that people's IEPs should continue to be implemented to the greatest extent possible. And so those accommodations in his IEP, if he needed them in a live learning setting, it's hard to imagine he would need them less now.
And the second one, I'm not sure that I understand it. I don't know whether I'm misunderstanding it or if I have typos. Is my ISP for my autistic son a binder contract? I have AFLS in his ISP. They have to use ABS. And they are refusing to pay for my AFLS, though it's in my ISP. And my ISP is not the same as IEP. So nothing is blinded in his ISP. I have no idea.
So break that down, take all the abbreviations out, explain it as if you were explaining it to somebody that knew no acronyms for your state, resubmit it, and we'll answer it on the show next week.
There we go. All right. So Bonnie, thank you. I'm going to let you go, but I'm going to give the disclaimer after you go. Good luck. And we'll let people know when that town hall is.
Great.
Have a good week.
Take care, everybody.
Thank you. Bye-bye. And the disclaimer there, Bonnie was giving advice, giving information. If you need legal help, go get legal help. You can reach out to Bonnie, and Bonnie is with the Tollner Law Offices, and you can Google her and you will find her. If you are in Southern California, I really encourage you to get Bonnie's ear and assistance. You'll have to fill out some paperwork, but you can have a free consultation and see how you want to move on from there. And she's incredible. If you need legal help other than Southern California, she had mentioned at the start of the show that they have legal help with the Tollner Law Offices in Northern California and in Arizona now, which is great. But if you need help in another area, she encourages you to go to COPAA.net and to find a lawyer there. We are not affiliated with any of those lawyers, but they are people who tend to care very much and to be in the know, let's say that. Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.